As Election Day approaches, Republicans are working hard to distance themselves, their party, and their presidential candidate from what is arguably their most successful and most unpopular policy, the undoing of Roe v. Wade. So you're hearing a lot of misdirection from the GOP right now, a lot of talk about how abortion has just been turned over to the states, about how they believe in exceptions to abortion bans. But as surely as we are all watching a parade of horror stories from women who are suffering and even dying as they are denied basic health care, Republicans are working even now toward what is and always has been the ultimate goal of the anti-abortion movement: to ban abortion nationally. And that's why it's more important now than ever to watch what they do rather than what they say, because what Republicans are doing right now is laying the groundwork for a ruthless federal abortion ban. I'm going to tell you today about just one of the many ways Republicans are actively working toward that goal as we speak. 3 Republican attorneys general from Kansas, Idaho, and Missouri are trying to revive a case challenging the FDA's approval of the abortion pill mifepristone. This is the same case, by the way, that the Supreme Court dismissed in June for lack of standing. Back then, the court found that the original plaintiffs, a coalition of anti-abortion groups and doctors, could not demonstrate that they had experienced any harm from the drug's approval more than 20 years ago. Kansas, Idaho, and Missouri initially joined that suit as interveners. This time, though, they're refiling as the plaintiffs themselves, asserting that they have standing based on the harms they claim their states have actually suffered as a result of the approval of mifepristone. Listen to this one. Kansas's involvement is especially surprising given the largely Republican state's voters there affirmed abortion rights in a 2022 referendum, making abortion legal. But Kansas Attorney General Chris Kobach, a Republican, is unfazed by this little detail of democracy and this expression of popular will, stating, quote, "We're pursuing this case to protect Kansas women," end quote. Never mind that Kansas women have already expressed their support for abortion rights. Kobach seems to think they voted wrong. Now, it's important to know that these 3 Republican AGs are not filing the case in their home states, where one might naturally expect the case to be heard, nor are they filing it in Maryland, where the FDA is based, or in any state where the pill is legally prescribed. Instead, they're piggybacking on a case that was previously dismissed, hoping to bring it back before the same specific federal judge in Texas who suspended mifepristone's approval in the original case, a decision that was later reversed by the Supreme Court. This is a brazen attempt to secure a favorable judge, and when you consider that a judge in Texas could override the will of Kansas voters in Kansas, it makes the move all the more audacious. According to the law professor David S. Cohen, quote, "It's a nakedly political judge-shopping ploy. If Missouri, Idaho, and Kansas are genuinely harmed by these pills, they should file in Missouri, Idaho, or Kansas. But they want to be before Judge Kaczmarek. So they're trying to piggyback on a lawsuit that had no standing in the first place and that shouldn't be allowed," end quote. Now, you might want to take a seat while I explain this next part. Because remember, these state attorneys general are refiling this case on the basis that their states are suffering harms because of the availability of abortion medication. And one of the harms they're citing is that because of the abortion pill mifepristone being widely available, not enough teenage girls are giving birth. They argue that lowered teen pregnancy rates deprive their states of future citizens and could even cost them a House seat and federal funding. I am not making this up. According to the amended complaint, quote, "A loss of potential population causes further injuries as well. The state's subsequent diminishment of political representation and loss of federal funds, such as potentially losing a seat in Congress or qualifying for less federal funding if their populations are reduced." This is 3 Republican men who are effectively arguing that women and girls exist for the purposes of churning out new babies for their states. According to reproductive rights writer S.P. Rogers, quote, "Idaho, Kansas, and Missouri are claiming to have a legitimate sovereign state interest in forced birth in teenage girls and women as breeders. It is an argument that positions everyone capable of birthing as brood mares, a scenario in which a state does not exist for the people, but the people for the state, and augurs a future claim for the prohibition of contraception, end quote. This is dark stuff. Beyond how dehumanizing this is to women, basic logic suggests that the state isn't being deprived of funds when there aren't additional citizens to serve. Yet here we are facing arguments that claim a state's interest in a woman's most personal and intimate choices. Because this was never about restoring states' rights, despite what Trump claims. It has always been about controlling women and their bodies. And Republicans will not stop until abortion is banned everywhere. Which is why the amended complaint focuses on the 1873 Comstock Act. It's a long, dormant obscenity law that prohibits mailing items that are, quote, intended for the prevention of conception or the procuring of abortion. The law was passed before women could vote. A 2022 Justice Department memo said the law should not be interpreted to criminalize most abortion pill mailing, but the amended complaint invokes this outdated statute, the Comstock Act, in an attempt to reverse several FDA rules that have expanded access to mifepristone, including lifting the in-person visit requirement and permitting the mailing of abortion pills. As more states have moved to ban abortion post-Dobbs, telehealth centers in blue states have expanded to fill the gap and to serve women in those states that are hostile to abortion. Today, in America, the majority of abortions are, in fact, carried out through medication, typically prescribed and mailed by these telemedicine providers. When Trump says he won't pass an abortion ban, it's because conservatives are counting on the Comstock Act, which was never formally repealed, to do their dirty work for them. Project 2025 explicitly calls for reviving the Comstock Act, which under a Republican administration wouldn't just ban medication abortion, it would restrict supplies used to procure abortions, making it nearly impossible for clinics, even those in blue states, to obtain equipment necessary for surgical abortions. In other words, the Comstock Act is an effective abortion ban. Understand that the goal is to ban abortion entirely and everywhere. And Republicans will not stop trying, no matter how many women are harmed or how many may die, until they find a friendly court or a friendly administration to back their agenda. Joining me now is Mary Ziegler, law professor and historian at the University of California, Davis Law School. She's also the author of numerous important books, including Roe, The History of a National Obsession. Mary, thank you for being here. I will say, Mary, I don't know when my team contacted you, but we struggled with this for a couple days because one of our producers said we should talk about this, and a few of us who, think about abortion and abortion rights a lot said this can't actually be true. They can't be making a case that it's about the protection of their population, that women should not be allowed abortion so that they can breed more babies for the state. And turns out, after talking to you, it's true.
Yeah, I mean, what's also really remarkable about this, I think most of us remember that encouraging teenage pregnancies in particular would have been seen as a valid state interest. During the George W. Bush years, for example, we were told not that teen pregnancies were good, but that abstinence-only sex education would prevent, teen pregnancy. And now we're at a point where we're seeing conservative attorneys general actually saying that the prevention of teen pregnancies is harming their states. That's really remarkable. It's hard to know what else to say.
Here's the reason it's hard to know what more to say is because you study this. You've written books about this. And on the surface, you would say that anybody with a third grade education would look at this and throw it out of court. Except that's not what happens in America these days. It's not what happens in Judge Kaczmarek's court. And it's not clear that that's what happens in the Supreme Court of the United States. So they're trying to revive this existing case. I remind people it's 3 attorneys general in different states filing in a state not where the harms are committed, not where the FDA is located, but in Texas. Is this legally plausible?
I mean, I think I would be surprised if Judge Kaczmarek doesn't find a way to advance this suit. And then the plaintiffs know they're going to be before the Fifth Circuit, which is by far the most conservative circuit court in the country. I think this kind of underscores the stakes of the election when it comes to the judiciary, because while our courts are generally quite conservative at the moment, the U.S. Supreme Court, at least before the election, looked at an earlier suit and said this just has too many procedural defects to move forward, no matter how sympathetic they might have been to the plaintiff's underlying claims. So it's worth emphasizing not only that this suit might have a chance to go forward, given how conservative the courts already are, but that the courts can change under a future Trump presidency, and people like Judge Kaczmarek or some of the judges on the Fifth Circuit might be elevated, right? The Supreme Court's composition may change, and even claims like this one with glaring procedural defects may stand a better chance than they otherwise would.
Okay, so I emphasized in the introduction this claim of an injury to those states based on their population, which, you know, like it's a different discussion for another day. We have negative birth rates all over the Western world. Different conversation. There are a couple of other claims they make. I'm hoping the other ones have more legal merit than this one, this nonsensical one.
Well, their other claims for standing have met some skepticism, too. These conservative states have been trying to intervene in another lawsuit brought by some progressive states, arguing that the FDA has too many regulations on mifepristone given its safety record. And the Ninth Circuit Court of Appeals has been skeptical that these states have standing on those other bases either, bases like the people are suffering injuries after taking mifepristone and are in hospitals, and those states are having to use their Medicaid costs to cover those expenses, or that the state's sort of sovereignty interests are being impacted by the flow of pills they don't want into their states. The Ninth Circuit, I think, was skeptical that this was anything more than speculation, right? That there wasn't enough evidence that this was happening. It was just the states surmising that it was probably happening. So there may be issues with standing. Regardless, I think those standing claims are less silly than the standing claim we've spotlighted.
Less silly, right?
There's no slam dunk here, I think.
It's amazing. Mary, thank you for the clarity you bring to this remarkably complex issue. That I mean, the only alert for the viewers is don't dismiss this stuff, because it's the stuff we used to just sort of ignore, thinking it's stupid. Stupid may become the law of the land pretty soon. Mary, thanks very much. Mary Ziegler is a law professor and an historian at UC Davis Law School. She's the author of numerous important books, including Roe, The History of a National Obsession.